Good evening everyone, and thanks for coming down to the Gold Coast Community Centre to attend this information event for victims of misdiagnosis. I'm a solicitor working on the Gold Coast, and I'm looking forward to walking you through the issues surrounding the current law on misdiagnosis claims and medical negligence and the required reforms enabling greater access to compensation for victims such as yourselves. We will begin by looking at the prevalence and effect of misdiagnosis on the Australian community and why this is such a big issue that we need to be concerned about. Secondly, I'll walk you through the current required elements of medical negligence, addressing specifically contentious areas. We will then turn to any defences that a doctor may be able to rely on. Finally, I'll present you with some potential reforms that would make obtaining compensation a more realistic and achievable exercise, including a no-fault scheme and legislative amendments. Here we can see the effects of misdiagnosis on the community. Implications of misdiagnosis are significant on the individual, and the consequences often fall onto their family and loved ones in cases where it leads to significant disability or premature death. You can see from this graph the high incidence of claims surrounding diagnosis. Predominantly, these areas include general practice, emergency, and radiology. Misdiagnosis in these areas accounts for a huge proportion of medical negligence claims, as reported by the AIHW. Worldwide, misdiagnosis is a huge problem. In the USA, 1 in 20 patients are misdiagnosed. In Australia, there is a staggering 140,000 cases of misdiagnosis occurring each year, where 21,000 of these result in serious harm and, alarmingly, 4,000 deaths. In the USA, it's estimated that misdiagnosis costs the government $26 billion annually, a significant economic impact. Misdiagnosis claims are difficult, complex, and time-consuming to resolve. 60% of claims are not finalised within 2 years of the date of claim, and 15% are not finalised within 5 years, which is concerning for patients who require compensation quickly to pay for medical bills or for lost time working. Improved laws surrounding this would not only reduce the incidence of misdiagnosis, but improve patient lives, longevity, and also reduce the economic burden on the government. The first element that must be met in negligence claims is the duty of care. A medical practitioner has a non-delegible duty to exercise reasonable care and skill in the provision of a professional advice and treatment. This is a single comprehensive duty covering all the ways in which a doctor is called upon to exercise his skill and judgment, including examination, diagnosis and treatment of the patient, as well as the provision of information. Rogers and Whittaker provides for an established category where a duty of care exists between a medical doctor and a patient, routinely applied in the courts. Luntz and Skeen indicate that in most claims against medical practitioner there is no question that a duty of care is owed. So whilst it is a relatively straightforward exercise establishing that a medical doctor owes a duty of care to their patients, breaching that duty can and has been a contentious issue in the Australian court system. The standard of reasonable care and skill required is that of the ordinary skilled person, exercising and professing to have that special skill, as per Rogers and Whittaker. It depends on a reasonable person's response to a foreseeable risk. It must not be an insignificant risk, with consideration given to the reasonable person response to the risk as per section 9(1)(a) to (c) of the CLA. The contentious nature of this provision links to how it applies to section 22 of the CLA as a defence that can be relied upon by doctors. In determining if there has been a breach of duty, the courts will turn to several elements, including seriousness of harm, probability that the harm could occur, and the burden of taking precautions to avoid the risk. For our purposes here, this simply indicates that it would be difficult to pass the stage concerning frivolous claims for trying to sue for incorrect diagnosis, where, for example, a pimple was in fact a wart, thus not meeting the element of seriousness. I want to discuss with you now some established cases where there will be a breach of duty. In Mules and Ferguson, the failure to conduct a physical examination on a patient by a GP, where little time would have been required to take it, and to better inform required treatment, will amount to a breach of duty. This was where a patient consulted her GP 4 times regarding the neck pain, and following the final consult was admitted to hospital where she was diagnosed with meningitis, leaving her deaf, blind and disabled. The doctor failed to assess the patient properly. The correct duty of care would have been to refer the patient to a local hospital for specialist assessment. In another case, the court held that there was a breach of duty where a gastroenterologist failed to perform a thorough investigatory procedure, stopping the gastroscopy once he discovered evidence of celiac disease, and thus missing the cancer that was on the other side of it. Another breach of duty occurred where a paediatrician treated a patient for meningitis instead of performing tests for a brain tumour. When the patient developed neurological symptoms, such as fixed and dilated pupils, the paediatrician still did not order a CT until the patient started having seizures, which determined the tumour. In order to establish medical negligence claims, the plaintiff must then show that the medical doctor caused the harm or damage. Under Section 11.1 of the CLA, the breach must have been a necessary condition of the occurrence of harm within the scope of liability. The doctrine of loss of chance comes into play when addressing causation issues in misdiagnosis. Loss of chance is where there is a failure to diagnose which causes the plaintiff to lose the chance to survive, recover from, or avoid the worsening of the injury. Originally, misdiagnosis courts had acknowledged loss of chance by allowing plaintiffs to recover for loss less than 50%. This occurred in Cavalis and Singh and Rufu and Hosking. Now causation is made significantly harder due to the rejection of the loss of chance doctrine in Tibet and Get. Under common law, causation is now an extraordinary challenge in misdiagnosis where the plaintiff must show they have suffered harm or damage caused by the breach of care, and that they must show they had a 50% chance of obtaining a better outcome if not for the misdiagnosis. The current law is described by Birch as can be seen on the slides. The unjust circumstances is where a patient, for example, develops a medical condition and has a 40% chance of full recovery and a 60% chance of developing quadriplegia. Say the doctor then fails to perform a correct diagnosis and breaches their duty of care. No action of negligence will be established, as there was always a greater than 50% chance of developing the injury. In Tibet and Get, the majority comprehensively rejected the notion of loss of chance in Australia. Birch highlights policy considerations were of concern, where such a doctrine would have opened the floodgates where doctors would be liable in almost every case of negligence. However, Birch goes on to suggest these arguments could easily be dismissed, as plaintiffs would still need to prove the breach of a duty of care, which would require the significance element, as discussed earlier. Secondly, causation would still need to be proved on the balance of probabilities, which is an onerous task in itself. And finally, the plaintiff would only recover if the prospect is significant. As in Naxicus and Western General Hospital, it must be of some substance. Lord Nichols identified the manifest injustice present in the absence of the loss of chance doctrine. He indicated it is rough justice. In two circumstances where a patient lost 45% prospect of recovery to a patient who lost 55%, both patients relate to a doctor who has breached the duty to his patient. In both cases, the patient is worse off. They both lost something of importance, of value, but one is compensated and the other is not. Further, there is no reason why the law should shield medical practitioners who breach their duties of care towards patients who have a poor prognosis. Their duties are devoid of all content because they will never be able to obtain compensation from the negligence. And that's from Gregg and Scott. But the High Court did not exclude loss of chance as forming a claim in medical negligence in the future. Faunce highlights that there may well be other cases in which a patient, as a result of misdiagnosis, has lost the chance of a better medical outcome. They refer to two international examples to indicate when this may be possible, including failure to promptly diagnose a gastric cancer, which results in an instead of a 37.5% survival rate to premature death as it had metastasized. Under Section 22, a doctor will not breach a duty arising from the provision of a professional service if it is established that the professional acted in a way that was widely accepted by peer professional opinion by a significant number of competent and respected practitioners in the field. Here the medical professional bears the onus of proof. Section 22 was developed from the Bolam test established in Bolam and Freen Hospital Management Committee, which was largely created in order to protect doctors from medical liability. This test was then rejected in Rogers and Whittaker. Following on from the IP report, recommendations were made to implement a modified Bolam test designed to protect medical practitioners from negligent claims if their actions were in line with what a reasonable body of medical practitioners would deem acceptable. And this comes from Stewart. Joseph Lee states that there are two main problems with the modified Bolam test that's present in section 22. The first is that it overly protects the medical profession at the expense of the injured person. It does not allow for an in-depth judicial analysis. Instead, emphasis is placed on expert medical opinion, and cases of irrationality would be rare. The implication of this is that medical doctors are more likely to be exonerated from liability where there has been negligence. The second issue with the provision is the phrase irrational, which has been difficult to interpret by the courts. In the past, it has been interpreted to mean illogical, unreasonable, or based on irrelevant considerations with no real consistency. Lee indicates that the role of the court should be more effectively discharged with a less ambiguous and a more flexible mechanism in allowing the courts to evaluate medical opinion. Reform is needed in medical negligence, specifically regarding misdiagnosis. Currently, Australia operates under a fault-based system which presents several challenges, delaying or preventing compensation to injured victims. This includes the need to prove injuries and satisfy thresholds such as the causation issues discussed earlier. The fault system and its reliance on the judicial system creates hurdles that are insurmountable for victims in terms of stress, cost, and overall an unpleasant experience. PIPA states that the average time it takes for a claim to open is 2 to 4 years in Australia and 4 years until closed. Doctors are also far too protected under the current regime, limiting access to compensation for victims of negligence. The two areas specifically concern the protection under Section 22 as a defence, which ties into the breach of duty under Section 91C. What I propose is two distinct changes, including implementing a no-fault scheme and alternatively legislative changes to incorporate loss of chance into the Civil Liabilities Act. What is suggested is a no-fault statutory scheme in relation to medical negligence. This legislative reform would run in a similar fashion to that seen in New Zealand, allowing victims to receive compensation without the need to pursue fault-based litigation. This would involve the establishment of a Medical Accident Compensation Corporation in Queensland. We recommend that funding is raised by the government and medical mandatory doctor contributions. The scheme would allow compensation to any victim of misdiagnosis who requires rehabilitation, treatment, weekly compensation for lost time at work, lump sum compensation for permanent impairment, survivor grants, and compensation for spouse and children and other dependents of the deceased, similar to that seen in Section 69(1)(a) to (e) of the Accident Compensation Act 2001 in New Zealand, allowing compensation for victims and their families. The benefits of this system include efficiency, as it's faster than a judicial system. In 2018, the average time taken to make a decision in New Zealand was 1.15 days, and time to compensate was 7.3 days. Therefore, claimants are able to access money quicker, especially important in terminal cases. There's substantially less stress in a no-fault scheme, and going through litigation is associated with poor health outcomes, including disability. Overall, this scheme would be less complex, cost-effective, and less confusing. There are some disadvantages associated with this scheme in that it could be unpredictable and victims may receive less compensation that they otherwise might be able to receive going through the judicial process. In the alternative, it's proposed that a loss of chance doctrine is incorporated into the CLA under Section 11 provision, stating that in medical negligence cases concerning loss of chance, the victim will be entitled to the percent that is proved that the medical professional has caused by way of misdiagnosis of the injury sustained. So therefore, in Bob's case before, under this new provision, he would be entitled to 35% of damages as compensation, as he should be. The purpose here is to keep doctors accountable and ensure they maintain their duty of care to patients, especially when these patients have a low prospect of recovery due to the carelessness of a doctor. Further benefit would allow patients to obtain the compensation they deserve to pay for incurred medical bills or time off work they have incurred because of the error. The people of Australia have legitimate expectations where, as a result of a failure to accord proper treatment, hopes are denied and anguish ensues. Compensation should be available through legislative reform addressing these issues. Thank you for listening, and I hope you have helped in some way.